Good morning. Welcome to the Foreclosure Defense Workshop Series. Today, this is CJ Holmes, founder of Homeowners for Justice and host and guide for your Foreclosure Defense Workshop. I have developed 11 considerations that owners, when they're facing the loss of their home, really should be considering. You need to at least think about these issues. But before we start, I'd really like to put on record a disclaimer. I must, because I can't guarantee this. Nobody can guarantee anything these days. And remember, we're fighting against lenders and servicers who use fraud as a business model. I just want to say I'm not an attorney. I'm not a CPA, I'm not a loan modification expert or a securitization audit expert. I am a licensed real estate broker in the state of California. I've done business for years, and my focus and goal has always been what is best for the owners. This is one of the motivations and reasons I've stepped into fighting against fraudulent foreclosure, and why I've put so much time and effort into freely helping anybody and everybody that will listen and will follow some instructions, take some advice, try to do these things on their own. And sometimes I can refer them to somebody that can help them, but I can't guarantee that. Everybody's situation is different. So please take a look at the legal disclaimer. Recognize that I don't endorse this. I can't guarantee the reliability. It's as good as I can get at this point. Please understand that. And that I can't be held liable for any kind of loss or damage that you might experience. Like that says here, direct, indirect, inconsequential, or other. Please understand that. Now, today, moving on, this is the beginning episode. There will be several short workshops on these various strategies, because some of them are fairly complicated, some are pretty straightforward. Today is just a basic overview, and there are currently 11 foreclosure defense considerations. Please understand that this can change. This is a live and a moving target. We're doing the best we can at this point in time. What I'm going to be doing is going through this particular foreclosure defense page. It's on hofj.org, the foreclosure defense, the very first page in foreclosure defense. And I'm going to go pretty much straight down the page today. The very first thing I want you to understand, I have a link here to judicial and non-judicial states. This is the quick guide, and you can take the link. This is just the picture of which states are judicial and which are non-judicial, and it will explain some of that different process and the time frames, and I'm not going to go into that right now because that's really not the point. The point is, owners might be facing the loss of your home and you just don't know where to turn and where to start. So start here. Determine first if you're in a foreclosure, a judicial or non-judicial state. If you're in a non-judicial, the documents, as we start talking about them, will be deeds of trust, your security document. In judicial states, it's a mortgage. And for now, that's all you need to know, really. So what we're going to do first, before we actually start talking about the specific 11 considerations, I really feel impelled to give you warnings. There's so many people and owners that have had insult to injury by liars, cheaters, and thieves that are outside the banks. These are people trying to make a living, lying about loan modifications, lying about foreclosure defense scams, lying about all kinds of things. And one of the things in particular that's very risky, more so than just losing money on somebody's lies, is actually buying into a scam where the owner records some kind of document themselves on the property. Don't do it. If you've already done that, I'm showing you an example of a rescission of reconveyance. If you've reconveyed that property somewhere and you're concerned that maybe this is not going to be legal, I highly recommend that you try to remove that from your property, because owners are the sitting ducks. We're sitting ducks for prosecutors that want to make good impression, look like they're really going after fraud, when really what they should be doing is going after the banks, but they're going to come after you. So a word to the wise, please pay attention to that. In California, foreclosure and loan mod consultants must be licensed, and you can find out if they are not by check. Now, I have the links on my webpage. If you look right down here, I'll just be jumping back and forth showing you. Here's the California desist and refrain orders for unlicensed loan mod activities and how to file a complaint. And this is what these web pages look like. Here's the desist and refrain orders. There's thousands of people cheating others. Check it out. If you have any doubt whatsoever, please just send me an email. Ask somebody that you trust to tell you about these issues and to help you understand that what they're probably saying isn't true. Here's how you can file a complaint with the state bar if you've got an attorney that's been cheating you. There's so many ways that people can be cheated and have their money taken from them, in effect, with false claims or false representation. I did want to talk about audits just briefly. I know there's a lot of people out there selling securitization audits, but often it doesn't do what the owner thinks it's going to do, what they may have been led to think it's going to do. It's going to solve your problem. It's going to keep your house from foreclosure. An audit in itself is not going to do that. Please understand that. Always get competent help, and if you need help and guidance, this is one of the reasons we've organized to try to provide honest help to owners seeking to save their homes. One of the very first defenses, now you'll notice down here in the corner, I've got them labeled as number 1, is filing a complaint with the Office of the Comptroller of the Currency. We will call it the OCC. It's right here as number 1. And literally for every bank, mega bank infraction, if your servicer is one of these, and I've got them here on the screen, and you can go to the website and check them out. We've got GMAC, or now known as Ally Bank, B of A, Chase, Citibank, Wells Fargo, or one of these other servicers, Aurora, Everbank, HSBC, MetLife, OneWest, PNC, Sovereign Bank, US Bank. These entities, plus the 5 megabanks I already mentioned, actually have signed consent judgments. This means that their behavior and their foreclosure efforts have been so fraught with significant problems that in 2011, the OCC, the Office of the Comptroller of the Currency, gave them a judgment, and they all signed off on it. Now the fact is, you wouldn't know it because they did not change their behavior. And this is why owners need to rise up and say, wait a minute, you did all these things and you still are doing them. And you're now going to take my house. You stole all those other people's houses the last 4 years. Now you're going to take mine. Here's what I wanted to show you with the comptroller findings. I just have to read some of these. That in connection with certain foreclosures of loans in its residential mortgage servicing portfolio, the bank, and these are the same consent orders for each one of them, in 2011, the bank filed or caused to be filed in state and federal courts affidavits executed by its employees or employees of third-party service providers making various assertions, listen carefully, such as ownership of the mortgage note and mortgage, the amount of the principal and interest due, the fees and expenses chargeable to the borrower, in which the affiant represented the assertions in the affidavit were based on personal knowledge or based on a review when they were not. They filed or caused to be filed numerous other affidavits or mortgage-related documents that were not properly notarized. These things make a difference, and this is the basis of these strategies that I'm sharing with you today. So read those documents. It is pretty enlightening and enraging. Once you understand, owners, that you're not a deadbeat, you are a victim in a massive fraudulent forgery scam, then maybe you'll get as angry as we are. So please check out the OCC complaint And this is the one strategy that rivals bankruptcy to postpone a foreclosure auction. It is our understanding, and it seems to be reliable, that once an OCC complaint is filed, the bank cannot complete the foreclosure with an open OCC complaint. So capitalize on it. The next thing that I want to talk about, strategy number 2, qualified written requests. These are the backbone of all owner defense. Not only is it a backbone of defense based on what you get back from the bank when you submit these letters, the servicer, when you submit these letters requesting information. Also, it proves in a court of law that you've exhausted your legal options, because that is really all of your options you have as an owner against a bank that's trying to foreclose, and you're saying, wait a minute, your information isn't right. It doesn't match what I've got. That's basically what a RESPA letter does. We call them RESPAs, the Real Estate Settlement Procedures Act. This will also, however, force information out of your servicer. For example, this mortgage-backed securitization trust that the loan was put in. This is crucial. All of these strategies build on things that the owners can do to help save their homes and fight off fraudulent foreclosure. This also, when the bank doesn't respond correctly or gives you incorrect information, it gives you more evidence for another OCC complaint or to amend your complaint with the OCC. Also, it will extend the statute of limitations for claims against the bank. So definitely consider this. We've got a sample here of a sample QWR, qualified written request, as a Word document. You can edit it to make it work for yourself, put in your name and loan number, that kind of thing. And the Consumer Financial Protection Board actually enforces RESPA issues, so there's a link to that. And then a couple of articles I think you might find interesting that actually talk about the servicers put the loans in many different mortgage-backed securities. What can I say? They're double dipping, triple dipping, quadruple dipping. That is the point. They're dipping, and we're the ones being dipped and cheated. The next one, if and when you stop making a loan payment, you may be inundated with phone calls harassing. There are practices. It's called the FDCPA, or the Fair Debt Collections Practices Act. I've got that here somewhere. There it is. A link to it on the website. This is for you, for your protection. And here's the link right there under number 3, stopping them. And here's sample letters, both in a Word document. But if that doesn't work on your machine, you can at least download the PDF file and retype it. And you can use this. And the servicers will abide by that. The next one I want to talk about, number 4, foreclosure document analysis. As I say on the website, in general, typically, you will not, a property will not have any assignments, trustee substitutions, notice of, any documents recorded other than the first initial deed of trust or mortgage until just before the notice of default is filed. And usually if you look at the documents, once they've filed a notice of default, you'll see that they're filed within like a few minutes. Same date, virtually the same time. And so if you've stopped your payments and you're in what I call limbo land, no payments, you may be sending letters back and forth, complaining about the loan mod treatment you're getting, submitting a qualified written request, but there's no notice of default, then you're not going to have any recorded documents. Only when the notice of default is filed, that's when this strategy number 4 comes into play, and you got to run down there right away to the county recorder's office and get these documents. This strategy is something we'll have another little training session on. I just want to bring it to your attention right now, because on the face of the documents, when you read these documents, you will see all of the fake titles, fake companies that are purported to be the beneficiaries, forged signatures, and false notarizations. And so this number 4, getting those documents understanding what you're reading, and then using the names and information you've collected off those documents to move into the next strategy of notary complaints. This is the foundation and the building block of owners actually pushing back against the banks to save our homes. The goal is we'll get millions of owners doing this. Then the owners can win. That's the key. So let's take a quick look at the next one, which is notary complaints. The notary complaints are fairly complicated because there's several different steps involved. I've got a separate web page. We'll have a separate guide on that. But in general, you need to understand the basic truth. It's called robo-signing. It's called bad bank practice. And what it really is, honestly, is forgery and fraud. Never make no mistake. They are brushing it under the rug with these dismissive terms. And one of the goals we have as owners and activists in this country is to break apart that myth that these banks just sort of messed up a bit and prove that this is an assault on the people to steal their land, because that is what it is. And you can read the rest of my website and see why I say things like that. So the notary complaints are based on, once you get the recorded documents, you look at which one, who notarized it. And so then you go to the Secretary of State to get a notary oath signature, because that's an original signature, and you compare. Do they match or not? The journal entries are what the notaries are supposed to have, the correct original signatures of the people that signed that document. So you go to the notary, send a letter out there requesting the journal entry. You may or may not get something. And then you look at both of those signatures, all the signatures on your documents, and go to a website like ours on Suspicious Signatures page and see if there are any other documents currently that we've got uploaded with those names on them that may or may not match your signatures on your document. This is the heart and soul of the proving the forgery and the fraud. I call them the building blocks of fraud. This is how we're going to trip the banks up and how we're going to gang up on them and get the foreclosure mills shut down, because that's really what we need. This is the first step. Stop the foreclosure mills from filing foreclosures. This leads directly into the next strategy, which is the owner's statement of suspicious documents. This is where we've taken all of the information from the recorded documents, from the notary complaints, from the samples of forged signatures, and we package that together. I've got an editable document that I'll be uploading soon. It'll probably be there by the time you look at this live stream or watch this little video. And you can edit that to match your situation. It quotes all the statutes and laws, rules and regulations, including the bank consent judgments that they agreed to. Yes, Your Honor, they said, in 2012. So not only do you have the OCC complaints and judgments, consent, cease and desist orders that the banks agreed to in 2011, which they completely ignored. Then you've got a court judgment in 2012. That's the basis of the Attorney General settlement, which they've completely ignored. So we have to fight back somehow. And this is how. The idea is we package all this proof of forgery, and then we plaster the planet. We make copies, multiple copies, and copies that have all of our personal information could be given to local county officials. Please send me a copy so I can make sure it gets to the grand jury for investigation. And then redacted copies where personal information can be deleted. Then make zillions of copies and send them to every media station on the planet. This is the only way I can imagine the owners, the people, the 99% breaking through and getting attention from mainstream media. There are some other actions that should be considered. We're going to just briefly mention them. Filing a quiet title lawsuit. Yes, that can be done by an owner. If you're like me and have never been in court and don't really understand the process, that can be overwhelming. So it's not necessarily required that you represent yourself, but it would be required that you have an attorney that understands how to use the quiet title lawsuit for your best interests on your behalf. I wanted to point out that one thing I've learned, and that is that in this lawsuit, in this action in court, the recorded documents the bank just sent to the recorder, they fake all these documents, send them to the recorder goes, boom, it's now recorded. And in every other lawsuit, those recorded documents are presumed to be accurate. This is why most of the time the judges don't even want the documents in, because they're presumed to be accurate. We don't want to look at them. So the owner comes to the lawsuit and says, wait a minute, this is not true. They lied, they cheated. It's not material. In a quiet title action, these documents are not presumed accurate. That's one of the powers of quiet title. However, again, it's based on state statutes. So the states, we've got 50 different states, so a quiet title action is not necessarily going to work the exact same way in every state. Certainly the laws quoted or the statutes quoted would not be the same. The next issues, the next discussions that people need to consider when they're facing the loss of their home is, can I qualify for a loan modification? A lot of people, most people, homeowners, just want to keep the house. They want a loan mod that they can afford. They want a servicer that will deal with them honestly and will give them a reasonable payment and a reasonable principal reduction, because now that the values have dropped in many places 50% or more, they just feel like it's not fair that I'm stuck in this upside down house, so upside down, particularly when now we know for sure that the banks caused the bubble. They caused it by stopping the underwriting and just throwing money away around. It wasn't even theirs. Well, actually it wasn't money, it was fiat credit. So nevertheless, they want a loan modification. I have a couple of warnings that I really want to emphasize, and I'm pointing out on my web page that I've linked, to several other sub-web pages about Fannie and Freddie, HAMP, Part 2, NACA, those kinds of things. But you must understand that trial loan modifications with no paperwork, where the servicer says to you on the phone, well, if you just send in half your payment, in cash via the transfer union, what's that called? I forget what they call it when sending cash, cashier's checks, send cashier's checks. When the servicer says that, gives nothing to you in writing, they're cheating. They're going to take that money, and that will never be applied to your loan payments. So don't get cheated. If they do this to you, if the servicer tells you have to default for 60 days before I can talk to you about a loan modification, or here's a trial loan modification, and if you don't do that, I'm going to foreclose, you file an OCC complaint right now. You get on that website, always file them by website. It zips right in, you get an email response that you've now got an open complaint, and you start complaining about these lies. You got to understand they're lies. Tell everybody you know in this country that those are lies, and the owners must stop thinking that the banks are telling them the truth. They are not. That's one of the key points in this battle. You've got to understand the servicers have a vested interest. They make more money foreclosing. And they have been allowed, they are getting away with lying, cheating, lying to you as the owner, cheating on the paperwork, forging documents, taking the house, and making profits, and trumpeting those profits on Wall Street. It's up to the 99% of us to stop them and make, I want to see some criminal charges, but at least stopping these egregious theft behaviors is a good start. So be sure that you've always used the OCC complaint. Also, if you've done the strategies, these don't take much, they take effort and time, but they don't cost a lot. Do the qualified written request. Start sending that out. Start tracking and logging. Protect yourself. Understand that we have rights. And when we quote the law, when we know the law, then we can actually stand on the law and get somewhere and get some justice for ourselves. Now, I want to cover three more issues, because many times an owner just either has no resources, lost income, just really needs to move on, can't take it emotionally. Pick a reason. There's many, many reasons why owners decide it doesn't matter at this point, I'm over it, I need to move on. And so a short sale is often proposed. For one reason, short sales typically can postpone foreclosure auctions. Typically, servicers will postpone an auction date if the owner has an active short sale in process. You have to understand, and as an owner, you must work with someone that really understands short sales, or it won't happen. They won't do the right things, they won't guide you correctly. You'll get yourself into a spot and get foreclosed and not get any move out monies. So, word to the wise, always work with an expert. I want to make sure, because most short sale agents that I know and understand and have worked with or dealt with, or people have talked to me about, do not understand and do not talk about the tax consequences on the owner on phantom gain. The phantom gain is the unpaid debt. So you owe, I'm picking numbers, you owe 400, you sell for 300, you're 100,000 short. That now becomes a gain. It's as if, with the IRS and your state, as if you made $100,000 that year and you owe taxes on it. So there are rulings. I've actually put those here on this under number 9, selling the home in a short sale. The Mortgage Debt Relief Act was extended for one more year to the end of 2013. It, depending on the state, some states are going to have this tax relief, others are not. It depends on the type of sale. It depends on the type of money. Was this the money used to purchase the house? We call it purchase money. Or was this a refinance? So all these different things, you can look at these articles. You have a question, just ask, email me. I'll try to get to it and answer you. But the issue is, go talk to your tax consultant. Your tax advisor will understand these issues very clearly, and your personal situation. So that's really the best thing for you to do, is to go to a tax advisor and understand that a short sale may hurt, but unfortunately it's not going to hurt any worse than a foreclosure, because the tax consequences are the same in the foreclosure in most states. So some states may have changed that. I know California did, and then they've rescinded that. So anyway, it's a complicated mess, and you have the right to know up front what things and tax consequences you as an owner might be facing in this situation, particularly if you've are trying to decide, should I just walk from the house? It's so far underwater. I could still afford the payments. They gave me a loan mod that's still a stretch. Should I take it? These are all the issues that owners are facing. It's very traumatic, and please understand, we do understand that. On a short sale, many times half a move-out monies are available to the owners. So that is something that also tends to motivate owners into a short sale. The government is trying to get, with their policies, to get people to sell short rather than foreclose, because basically you get a higher price for the house. At least that's what they are saying. Frankly, I'm not sure I agree, but we won't go there. Here's an option that is given to owners a lot in their letters. They will get options. You say, the letter coming back from the servicer will say, I'm sorry, you're denied the loan mod, forget you. So you can do a short sale, or you can do a deed in lieu. They call it a deed in lieu, and it's a deed in lieu of a foreclosure auction. The idea is it's less stressful. The owner understands that when they sign, they just sign the deed back to the bank. They don't fight, they give up, they give in, they say, I'm done. And definitely it can be less stressful currently. Now you have to understand, owners in particular I'm speaking to, that down the road, if you start looking at my website, you start finding other people that have fought and gotten excellent loan modifications, or even better, getting some restitution from the banks for fraud and forgery. You may regret this decision. So Give it some thought. Make sure you understand the tax consequences. And then the last issue I want to mention here, just in passing, because I'm not an attorney, I don't do bankruptcy. I know I have contacts that have done bankruptcy by representing themselves in court. Generally speaking, just this is a quick aside to court representation of yourself, it usually absorbs your entire life. It becomes an obsession, and many people don't have the time or effort or capacity to do that, and I totally understand it. If you use an attorney for bankruptcy, please, 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 this is the one thing I've learned from all of the discussions and all the contracts and all contacts and attorneys and information that I've gathered up over this last year and a half of fighting to stop fraudulent foreclosures. Make sure that the loan on the house is listed as unsecured debt. Do not list that as secured, collateralized by the house. List it as unsecured. And if your attorney won't do that, dump him. Get an attorney that will. This is absolutely crucial because this is the only way that it is even possible to get the judge to look to the servicers, banksters' attorneys and say, well, this should be secured on the house, right? So who owns this loan? And that's the question. Who owns the loan? Because the answer is, in virtually all of these securitized loans, no one has the right to foreclose. We just need to step up as owners and make sure we keep the homes for ourselves, keep our homes, and stop them from taking homes that don't belong to them. Thank you for watching. This is CJ Holmes signing out on the workshop for the 11 considerations owners should be thinking about when they're facing the loss of their home.